Today we're going to talk about some Second Amendment history in the modern context. Specifically, how did Vice President Dick Cheney help save the Second Amendment, and contrast that to his daughter Liz Cheney and some of the nonsensical things she's recently said about quote-unquote gun violence, a propaganda term by the left. Stay tuned. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner channel, please do so. Show your love for the right to keep and bear arms. And if you're on Twitter, please follow us at Four Boxes Diner for additional information I put out for that audience, in addition to the audience here on YouTube and beyond. Okay. So we all know that the former Congresswoman from Wyoming, Liz Cheney, the daughter of Vice President Dick Cheney, was recently kicked out of Congress and voted out of office for nonsense she engaged in with the January 6th committee, which we will not get into here. What we will say, though, is this recently she put out a silly tweet, in my view, attacking effectively the Second Amendment. Now, let me tell you what she wrote. This is what she said on Twitter. Quote, "If we really want to keep our children safe, we need to spend less time banning books and more time stopping the horrific gun violence in our schools." Now, that is what Liz Cheney said. Now, set aside the book banning issue. She refers to the notion of gun violence, which, of course, is embracing a propaganda term by the left. She obviously spent far too much time on that January 6th committee with anti-gunners. It may have rubbed off on her. But with that said, obviously, she should not be engaging in anti-gun propaganda because that would disappoint, among others, her father, Vice President Dick Cheney. Now, I want to talk about a story that is only known really to super high-end Supreme Court geeks. Because why would anybody know what I'm about to tell you unless you are a Supreme Court follower in the geekiest fashion? Let's go back in time to the year of our Lord 2008. As you know, that is the year the Supreme Court issued the Heller versus D.C. decision. But I want to step back earlier than that a little bit, specifically to the legal briefs that were filed in the Heller case. As you may recall, 2008 was the last year, right, of the presidency of George W. Bush. So therefore, the Heller case was being litigated when George W. Bush was the president of the United States. Now, the reason why this is material to this discussion is the vice president of the United States was, of course, Dick Cheney during that time. And the reason why all that is relevant to what I'm about to say is that the Solicitor General of the United States, who is part of the Department of Justice, who is responsible for enforcing federal law, was an appointee by George W. Bush. The Department of Justice, through the Solicitor General's office, has a duty to uphold federal laws, including federal gun control laws, as a general matter. It's not always true, but generally speaking, it is sort of the responsibility of the Department of Justice to defend laws. Now, the reason why this is significant is that the Solicitor General brief, which was filed on behalf of the United States Department of Justice in Heller, if you read it, and I'll put a link to it down below, was, in my opinion, and I'm guessing in your opinions too, a little weak tea-ish, meaning it did not robustly defend the right to keep and bear arms with the proper standards the way it really should have. It came out to the right conclusion that the Second Amendment protected an individual right to keep and bear arms, and that D.C.'s law banning handguns was unconstitutional. So the conclusion was correct, but a lot of the arguments and rationales set forth in that brief by the Solicitor General's office in Heller was a little bit softer and a little bit more weak-kneed than, in my view, it should have been. Now, this is significant, and you're like, why do I care about that, Mark? Well, remember, Vice President Dick Cheney was part of the Bush administration. So technically speaking, when the Solicitor General of the United States, on behalf of the Department of Justice, submits a brief, they are speaking for the federal government, which would include the President of the United States and the Vice President of the United States, correct? Because they're all part of the executive branch. The President, the Vice President, the Department of Justice, and the Solicitor General's office are all part of the executive branch, which is supposed to enforce federal law. Now, here you have a situation where the Solicitor General submitted a brief which reaches the right conclusion supporting the Second Amendment, but a lot of the things being argued in there were not necessarily as robust and protective of the right to keep and bear arms for future cases as perhaps someone like myself would want. So what did Vice President Dick Cheney do, and how did this help us save the Second Amendment? Well, it turns out 55 members of the United States Senate filed an amicus brief written by Stephen Halbrook, the famous Second Amendment historian who's been on this channel before. Vice President Cheney, in his capacity of the President of the Senate, did you hear what I just said? When you're the Vice President of the United States, you're the Vice President of the United States, which means you're part of the executive branch, but you have a unique skill set, or you have a unique job, I should say, which is that you're also the President of the United States Senate, which is part of the legislative branch of the United States. So again, what happened in Heller in the briefing before the U.S. Supreme Court? Vice President Cheney had no duty to do anything. He could just sit on his hands and let the Solicitor General's brief on behalf of the administration speak for him and the rest of the executive branch. But he did not do that. No, he did not. So Vice President Dick Cheney puts on his hat as the President of the Senate and approves and signs on and becomes a party to the amicus brief that is signed by 55 U.S. senators and I think something like 250 members of the House of Representatives, authored by his Second Amendment historian Stephen Halbrook, who's a constitutional lawyer, who's argued case before the Supreme Court. Now, the reason why this is important is that the arguments made in the Halbrook amicus brief were far more robust and powerful in protecting our right to keep and bear arms. He talked about the history of the founding era evidence. He talked about what the framers thought in that brief. They talked about the Freedmen's Bureau, which was an attempt after the 14th Amendment in the Civil War to allow freed slaves to have their right to keep and bear arms in the late 19th century. He talked about Reconstruction history, which again was an attempt to try to get the freed slaves to be brought up to speed so they could be full-blown citizens, which of course included the right to keep and bear arms under the Second Amendment. And basically, it was a powerful rendition of why the Second Amendment protects the individual right and why it should be robustly protected in American life, far more so, in my view, far more powerfully and more persuasively than the Solicitor General's brief one. One was a little soft. In part, the excuse there is because the Solicitor General has a duty to defend federal gun control laws as a general matter, so they probably had to play a little bit soft to protect federal power under their duties of working for the Department of Justice. But, Professor or historian Halbrook did not have that, and Vice President Cheney, rather than signing off on the Solicitor General brief, which was sort of weak need when it comes to the Second Amendment, he actively goes over and signs the brief in this capacity as President of the United States Senate. And I'm happy to say, as well that the views articulated by that Halbrook amicus brief, signed off by 55 U.S. senators, 250 members of the House, and President of the United States Senate, Dick Cheney, back then prevailed in the Heller case, hugely so, and now we see that the Second Amendment is now viewed no longer as a second-class right. It's now viewed as a fundamental right, and I think we can thank, in large part, Vice President Dick Cheney, the President of the United States Senate, at the relevant time when that Halbrook brief was submitted to the Heller case. And if you look at the Heller case and you compare it to what was put in that Halbrook brief, you'll see that the Halbrook amicus brief, signed off by, among others, Dick Cheney, was very influential in Justice Scalia's opinion in Heller, and I think much more so than the Solicitor General's brief. For example, just to give you one example of why I say that, if you look at the Solicitor General's brief submitted by the U.S. government in Heller, they asked that the case be remanded back to the lower courts for an analysis as to whether or not handguns are protected by the Second Amendment. The Halbrook brief says absolutely not, there's no need for that. And the Heller decision itself by the Supreme Court embraced the Halbrook view that obviously handguns are protected arms. We don't need to get into any fact-finding or trial on the issue. They're obviously protected because they're in common use by Americans for lawful purposes, and that's all we need to determine that handguns are protected. That's like a simple example where the Halbrook brief was adopted by Heller and is much more favorable to Second Amendment rights than the Solicitor General's brief was in the Heller case, which again was a little bit milquetoasty as I see it. And just to show you on that remand point, this is the final argument made in that Halbrook brief signed off on by, joined by Dick Cheney. This is what it says, quote, "The district's prohibitions on mere possession of law-abiding persons of handguns in the home and having unusable firearms are unreasonable per se. No purpose would be served by remanding this case for further fact-finding or other proceedings. The Supreme Court took Professor Halbrook, historian Halbrook's view to heart, and that is exactly what they concluded, which was a different position than the Solicitor General's position in that brief, the same brief that Vice President Dick Cheney apparently refused to sign off on because he signed a separate amicus brief from the SG's brief. I think that's quite significant. So when Liz Cheney is out there making comments about propaganda in terms like gun violence, I would like her father, Vice President Dick Cheney, perhaps, to take her aside and discuss the importance of the Second Amendment, to remind her that this is important not just in her state of Wyoming, but all across the country, because the Second Amendment doesn't just apply to some parts of the country. It applies to every nook and cranny of this country, and I'm glad it does. Okay, folks, hope you learned a little bit something here today. I hope this wasn't too modern-day geeky. If you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.